Is this extraordinary testimony we received from a former State Department official. He's the former director of the Office of Information Programs and Services, which essentially is the Freedom of Information Act office, involved with obviously responding to FOIA requests, handling records generally for the State Department. And a gentleman's name is John Hackett. He's no longer there, and you'll see why in a moment. But he testified that he had raised concerns about Hillary Clinton's emails use repeatedly. Specifically, he raised also concerns about how her lawyers were going to review all those emails that she took, ignored, and plus he raised concerns that they were interfering improperly with email productions to the Congress and to the public related to Benghazi, interfering in a way that placed our national security at risk. So when I say blockbuster, I mean it. So Hackett was a part of court-ordered depositions and testimony that we were granted by Judge Royce Lamberth, who, as part of a Benghazi FOIA lawsuit we pursued, was quite upset that the government tried, the State Department and Justice Department, tried to hoodwink the court and shut our case down before they fessed up to having Clinton emails that they were trying to hide from us. And so he granted us discovery. We deposed our attorneys we're essentially completed that first initial round of discovery. Our attorneys have questioned about a dozen witnesses in the last few months. We've gotten new documents and other things. And some of the highlights of the testimony we've received thus far, both written and in person. Remember, Hillary Clinton's lawyer testified she got immunity after she deleted the 33,000 emails. The top FBI official who was supposedly investigating the Clinton email issue, admitted that they found Clinton emails in the Obama White House, the executive office of the president. The top security official at the State Department, deposed by us, he admitted they warned Hillary Clinton not once but twice about her email practices, or specifically about don't use a BlackBerry and be careful about the use of personal emails for government business. She was warned. And then we found out additional documents showing that the Obama White House was involved in the cover-up and lies about the Clinton email system. I mean, one of the big issues is that, well, no one figured it out until late in the game that Hillary Clinton had this email system. That's not true. Well, go back and think about it like this. Hillary Clinton is the head of the State Department. She knows about her system. Her people know about her system then. The State Department knew from the beginning. And certainly they knew generally as a matter of under the law related to the Federal Records Act and the Freedom of Information Act for years. But then they couldn't avoid the issue because people started asking specific questions on her emails, and that's when they started lying to the American people about it and misled the courts and Judicial Watch. And that's why there's this email scandal, because not only was there the mishandling of classified information, but you also had the misleading of federal courts, Congress, subpoenas, things like that, that were all of which were impacted negatively by the big lies about the Clinton email system. So the judge wants to know, was there an effort to hoodwink him? There's no doubt there was. He also wants to know whether Hillary Clinton used her system to avoid the Freedom of Information Act. No doubt that happened. And then more as importantly, because it's FOIA, well, where are the other emails that may be out there that Judicial Watch and the American people have a right to have reviewed and released to them, specifically Clinton emails. And this is all in the context of a lawsuit about Benghazi. And so the judge wants to know, was Benghazi one of the reasons all of this scamming took place? They didn't want us to know about the emails because they were afraid what might be in there about Benghazi? Well, you'll see that may be the case here. So getting back to John Hackett, he's this former top official in the State Department involved in records management. And he was blowing the whistle repeatedly on what Hillary Clinton was doing. In June of 2013, there was this famous photo, you may have seen it, Hillary Clinton's wearing a dark pair of sunglasses, looking at her BlackBerry. And I think she used it for her first Twitter picture or something like that, or associate with her Twitter feed when she opened it. And this is what we say. Hackett testified about his initial concern over Clinton's email use arose in June of 2013. Now remember, we weren't told about her email use publicly until March of 2015, almost 2 years later. He saw that photograph and he thought, and this is a quote, "And that got me thinking, well, what was that BlackBerry?" Because the picture was of her on a government plane. Was it a government BlackBerry? And if so, were there emails relating to that BlackBerry? Oh boy, that's an inconvenient question. And he went and talked to his director, Cheryl Walter. And she said, after seeing that photograph, and suggested we had to be careful about what sort of responses we made related to Hillary Clinton's emails. If there was a no records response, that was being given out. So they were giving no records response, lying when people were asking about Clinton emails. And he said, well, we have to stop saying that. And so you know what they did? They essentially just stopped answering the requests, wouldn't tell them anything one way or another. So they specifically and actively hid her email usage from those seeking these records as they're able to under law, including Judicial Watch. You know, and he looked up and he pursued it further. He said the other thing that we did, or I did at the time, was we wanted to find out what this BlackBerry meant. So we tasked, my recollection is, we verbally tasked the department's records manager at the time to look into the BlackBerry. And they asked Clarence Finney, who was the secretary's manager of records in her specific executive office, to ask him what he knew about the emailing habits. And she didn't find out much from him. And she asked the State Department, that's part of the intelligence community, and they asked to see if there were any classified emails on the classified systems that the secretary might have produced. And they said they didn't have any. So there was a lot of confusion about exactly what that BlackBerry meant at the time. You had a concern as to how the department was responding to FOIA requests that related to Secretary Clinton's emails after you saw the photograph holding a BlackBerry. My recollection is, and I had been there 2 months, that someone had told me that, and I can't remember, that she did not have an email account, a government email account. So there was obviously a contradiction here when you know there's that photographs. So we're just there trying to find out what was the ground truth. So that's why I had a concern about issuing responses that said no records had been located. You know where the records were? Well, I guarantee you some of them were in the State Department because she was sending emails in the State Department. She had taken them improperly when she left office. So what's even worse is, he wasn't asking a question they didn't already know an answer to. He was being gamed, it looks like to me, by his colleagues in the supervisory staff at the State Department. Why? Because the State Department at that time had already been lying. They had said there was a no records response despite knowing that there was this Clinton email issue out there. And that no records response, that lie, was set up in consultation with where? The Obama White House counsel's office. So Judicial Watch's other discovery found that the Obama White House counsel's office was orchestrating the no records response on the Clinton email issue. So, you know, when you wonder why Hillary Clinton hasn't been prosecuted yet, you know, one of the answers is because you can't prosecute her without raising issues about the conduct of other people in the Obama administration, including in the Obama White House. So Mr. Hackett had this inkling something was up, right? And so fast forward, Judicial Watch's FOIA in this case, and another case about her conflicts of interest, kind of forced the State Department's hand. They know there are these records out there. The FOIA requesters, like Judicial Watch, aren't going to take, are going to figure out something's up. They had given something to the Benghazi committee, which was formed thanks to Judicial Watch disclosures, suggesting there were Clinton emails, and they knew they were going to have to confront that as well. But it was in our case, in this case specifically, that they first admitted that there were other records they need to search. They didn't tell the court honestly what those records were, which were all the Clinton emails. So Hackett knew about these other emails. So she had taken 60+ thousand emails and only had returned 30,000. And Hackett was concerned, well, why are we relying on Hillary Clinton's people to tell us what government records are? She had no right to take those business records with her, but she did it anyway. And she said, well, I'm going to tell you what you're going to get back. And this is what Hackett knew something was up in that regard. And he talked to the State Department about this. I recall it wasn't much of a conversation. I mean, we have to say it was emphatic to the Undersecretary of Management, who was Patrick Kennedy, really top official there. And I didn't speak in tones like that very often to him. So he was pretty aggressive. You know, that we needed these guidelines, meaning that when you look at a government record or a document, you've got to know what the rules are in deciding whether they're government or personal. And of course, you don't outsource it to a Clinton lawyer to do it. And when you said the Undersecretary, were referring to Patrick Kennedy, he says yes. So our attorney asked, and then he goes, I think there might have been raised it with two other people, Rich Visick, who another senior official acting office of legal advisor, lawyer, and Peggy or Margaret Grayfeld, who was an executive level State Department FOIA officer. She's since passed away. She's been the FOIA person from our, we always recognize her name because she was always responding to Judicial Watch FOIAs. Why did you, and our lawyer asked, why did you feel so strongly that this was necessary that they provide the information? Well, we heard there were 50 or 60,000 emails, and they being the Secretary's team, had culled out 30,000 of these, so we wanted to know what criteria they used. The standard for the National Archives is very strict. The National Archives sets records policies for the government agencies. If there were mixed records, that would be considered a federal record. If there was mixed personal and mentioned a discussion, there would be, under the narrow National Archives rules, it would be considered a federal record. And do you know if the emails that were returned by Secretary Clinton and her attorneys, that they followed the guideline to include an email that would include mixed information of personal or official? I don't know. Was a request ever made by Patrick Kennedy or anybody else who you raised this to? Ambassador Kennedy told me he would ask for the guidelines. Do you know if the guidelines were ever provided to Patrick Kennedy? Hackett, not during my tenure at the State Department. Well, let me break that down for you. Because Hackett, it's even worse than what Hackett suggests. The irony is, when Hillary Clinton was Secretary of State, as she's writing emails, under the rules and regulations at the time, she could decide which is government, which is personal, and she could have just deleted personal emails as she was writing them, or on a regular basis. There's nothing that prevented her from doing that. But once she left office, all of those records became government records immediately. So she shouldn't have been able to take any of them without a review, in the least. Now, she might have gotten copies of some of them. She certainly would have been able to take classified information, which she improperly did, which is just an outrageous violation of the law. But even her personal emails, the government would have kept. Because, once you're gone, they're theirs. It does not mean that Judicial Watch or anyone else would get, quote, personal information under FOIA. Heck, we don't want personal information under FOIA. We are asking for government records. So if she's setting up yoga classes or wedding planning, the big lies she was telling about what was in the emails that she deleted, we wouldn't be getting those under FOIA. And that's not the issue. The issue is she took emails that she wasn't able to take, and then when the government wanted them back, because their hand was forced by Judicial Watch, she and her lawyers decided what was going to be government and what wasn't. And sure enough, because Judicial Watch did receive the records that were deleted, at least some of them, there was classified information and government records among the records that were deleted or otherwise hidden. And if they had listened to John Hackett, if they had followed the rules from the beginning, not one of those records would have been deleted. Because, you know, depending on which report you read, I don't know what the FBI suggests, told one news outlet that they got 17,000 records recovered. I don't think that's true. Based on our analysis, the FBI was only able to recover 5,000 of the 33,000 emails that Hillary Clinton and her lawyers deleted. And we know among those records that were those personal emails that were deleted were plenty of government records, because we got them. We wouldn't get them if they weren't government records, and classified information. And if people like Hackett had been listened to, if the rules had been followed, if they had followed the law the way they were supposed to, none of that would have been deleted. None of that obstruction would have taken place. And they allowed it to happen. That's why I say testimony like this ought to blow it wide open. Because they all knew at the State Department what was going on. They were warned, they knew directly, and to the degree they say, I didn't know, they don't have any plausible deniability, because you had people like John Hackett, this eyewitness, come in and tell us he told people and warned them about it. Isn't all that outrageous? But it gets worse. There have been rumors that, and I talked about this, and I hope you're able to review a discussion I had with one of our lead attorneys on the case, senior Judicial Watch attorney, Ramona Kotka. And and it's hard. We're a transparency organization at Judicial Watch, and so we get documents. We like to get documents. We like to get more information rather than less. We're happy when the government errs on the side of disclosure and gives us more documents. Having reviewed hundreds of thousands of documents in my 21 years here at Judicial Watch, this is my 21st anniversary at Judicial Watch, believe it or not. So I've looked at a lot of documents. My colleagues have looked at a lot of documents. I have a pretty good feel about what documents, what typically is withheld under classified information, what is classified, what isn't classified, what you ordinarily get, what you don't ordinarily get. And reviewing many of the Clinton emails, what struck me is that there was material in there that could have been classified. Like I said, there are probably few people in Washington, D.C., as few organizations, and at least in Washington, D.C., who's had as much experience reviewing government records under the Freedom of Information Act as Judicial Watch has. Dare I say it, no one else has, given the sheer volume and the millions of records we've received. And I remember thinking, well, I'm not going to complain, we're getting these records. I'm not in a position as a layperson to say that needs to be classified, but my thinking was that they were releasing material that otherwise should have been classified because they were trying to protect both themselves and Hillary Clinton from any additional criminal liability. The more classified information, the worse it looks from a prosecutorial perspective for Hillary Clinton. So like I said, I have suspicions, but I always have lots of suspicions, but I don't necessarily have evidence to back up these suspicions in this case, other than my own experience, however extensive. Well, John Hackett confirmed my suspicions. And this is how he did it, because he testified that he was concerned about interference in the document release process, the FOIA process, especially as it relates to Benghazi. And he testified that they were, let me get to the section of the document about this, forgive me here. Judicial Watch asked Hackett, he believed that there was interference with the formal FOIA review process in 2014, because that was when they were getting Hillary's emails. Hackett said he believed that some bureaus were convinced, and analysts were convinced, once it was explained to them to redact something but use a B5 exemption versus a B1 exemption. What does that mean? B5 is a non-classified exemption that allows the government to withhold what is called deliberative process material, basically the back and forth before a final decision. It's material we're often very interested in, we often don't get. And it's a big loophole that prevents the government from giving us a lot of documents. B1 is the national security exemption. So when you're classifying something or withholding something under B5, you're saying that underneath it, underneath the black marks that you often see with redactions, there's nothing classified. But when it's B1, they're telling you underneath those black marks, it's classified. And what Hackett is saying is that they were underclassifying and mislabeling classified material as unclassified in producing these records to the American people and to Congress. And he also testified that the lawyer involved in this case, Catherine Duval, who, by the way, comes from Lois Lerner land at the IRS before she went to the State Department, that she wasn't doing the proper consultations with other government agencies, you betcha, about classified information. So it was a double whammy. They didn't want other agencies to get involved and start classifying stuff in a way to make Hillary Clinton look bad. And then when they had the decision power, making power themselves, you had State Department officials underclassifying and interfering with the process. And so when you underclassify material, it means you're telling people it's not classified and you don't need to treat it as classified, which means it's not protected from disclosure the way it's supposed to be. It's not put on a secure system in the State Department. The Congress doesn't treat it as classified. National security was put at risk as a result of this cover-up activity to protect Hillary Clinton. That's what this testimony shows. Attorney General Barr and the Justice Department have more than enough evidence, uncovered by Judicial Watch, of course, to reopen the Clinton email investigation, to not only investigate Hillary Clinton, but her former colleagues at the State Department, frankly, in the Obama White House, and in the Justice Department itself. They were all in on this. They were all in on it. I mean, as if Benghazi wasn't bad enough, 4 people got killed. And then they lied about it. And then they got caught with emails, having an email system as a result of our Benghazi investigation. And they doubled down on the damage to our national security by releasing stuff improperly. And it isn't Judicial Watch saying this. This is a testimony of a former State Department official. So just incredible material. And, you know, I say it once, I'll say it again. Judicial Watch is doing the heavy lifting here. It was Judicial Watch that obtained this testimony. We received other testimony, as I said before, about the Obama White House being involved in the cover-up, Hillary Clinton being warned twice about email usage and security issues, warnings she acknowledged. And they were lying repeatedly. The State Department knew almost immediately that Hillary Clinton was using an email system that wasn't being searched in response to FOIAs, congressional requests, and other inquiries. Who knows what other lawsuits and other things that were going on there. And ever since this has been uncovered, we face nothing but obstruction and objection from the State Department and the Justice Department. And it hasn't stopped. You heard me, it hasn't stopped. This discovery that we received from the federal court judge, it came over the outrageously dishonest objections of this Justice Department. Thankfully, the federal court judge said, you know what, it's bad enough what went on during the Obama administration. He said, why is this Justice Department still defending the indefensible? He didn't use that language, but he essentially said it. And thankfully, he granted us this discovery. We got the goods. So no more excuses. I don't know what they're doing now. Attorney General Barr, he's expressed interest in looking and re-looking at this Clinton email issue, and I hope he does it. Certainly, we've got the documents, we've got the goods if he wants to do anything else on it. Statute of limitations hasn't passed on a lot of these email crimes and lies, so he should be able to do something if he wants to exert the political will to do it. And in the meantime, we're going to evaluate all the testimony and evidence we've received and figure out what to do next, maybe ask for additional testimony to get more accountability, because this process, we're an educational group. So this discovery that we're getting obviously is important to the court process, but because we publicize it in a responsible manner, we put the deposition I'm talking about, I encourage you to go to Judicial Watch's website and download it. You can look at it yourself. We have a video of the deposition, but you can't see that. You know why? Because this Justice Department and this State Department convinced the court not to allow it to be public at this time. So you can't look at it. But you can look at the deposition transcript. So I encourage you to do so.